Judge, first of all, we are not disputing he entered pleas of guilty to the kidnappings and the abduction, so we are not disputing that she was held against her will for a portion of this event. We are not disputing that she did suffer serious physical harm. What I will tell you a little bit differently, Judge, if you see the very first video that they showed where Mr. Mozingo was talking to her about payment, are you going to pay me for that cigarette? Are you going to pay me for that cigarette? The bottom line here, Judge, is Mr. Mozingo did not promise her that if she came with him, he would provide safety and security. He promised her that he would provide methamphetamine. So at least at the beginning of this, and if you look at the victim's statements throughout this and her statements to the hospital, this started out as a totally consensual, there was no issue because frankly, they're both getting high together. At some point in time, it goes south and things change. So when you watch those videos and when he calls her a bitch and when he calls her a whore and when he says he's going to cut her head off and all kinds of things like that, that still does not change, I don't think, the legal analysis that you have to do. So we've already, I believe, agreed that the two kidnappings and the abduction, they would merge for the purposes of sentencing. They talk about the felonious assaults being the various different injuries. She did have a broken fifth metacarpal on her left hand. She did have a broken nose. She did have a subdural hematoma. But to say that they happened at different times over the course of 4 days, or we would say 3 days, but regardless, I don't think that they can show that that happened. I mean, frankly, Judge, if these injuries happened when my client hit her with a baseball bat and that caused her broken nose, and she's trying to defend herself and that causes the broken wrist and that causes a subdural hematoma, that's one animus. So if he slapped her on day 2, that's not a felonious assault. And if these injuries happened with the one beating with the baseball bat, that's one count of felonious assault. And I think the burden is on the state to prove that these injuries happened from separate times. Even if she was assaulted, misdemeanorly assaulted on these various different days, they have to prove that the various kinds of serious physical harm that she suffered resulted from separate animus, not at the same time. And I don't think they can show that, even if the court chooses to believe that this assault took place over a couple of days. I don't think legally that they've shown that. I think the most important video that they showed was, I think it was the third one where Emily said was going to be very loud. What happens in this situation, Judge, is they are living in a garage, and there are beams 10, 12 feet up in the air, and there's plywood on those beams, and that's where they would sleep. The video that you saw, video number 3, is at one point in time, and Chloe admits this to the cops, she admits it all over the medical records, that collapses, and she falls down without able to brace herself from 12 feet up in the air. So, do injuries come from that? Well, again, I think the burden is on the state to show that these are all separate animus. I don't know if black eyes are a separate serious physical harm. I do know that if you've ever broken your nose or seen anybody with a broken nose, the eyes are impacted the same way. Judge, he does have a record. We've discussed that. You know that. What I'm asking the court to consider is, on the kidnapping, because he has the priors, give him 11 to 16 and a half. On the felonious assault, you know, Chloe's mom said he pled guilty because he didn't want to hear her testify. In a way, that's true, but he pled guilty because he didn't want her to go through what would probably be the worst day, which is definitely the worst day of her life, frankly, on national television. I think he deserves credit for not letting her do that. I would ask you to give him 5 years on the felonious assault, and I do believe that they merge, and then 2 years on the escape. If you run those consecutive, that is 18 to 23 and a half. I think it's appropriate in this case. I think, people that murder people, Judge, in the state of Ohio, get a chance to get out at 15 years. I think a sentence of 18 to 23 and a half is appropriate. I would ask you to merge those felonious assaults because I don't think the state has met their burden to show that there was a separate animus, and it is their burden. They have not done that. And again, 18 to 23 and a half, I think by that time he will be well into his 50s. That's what I'm going to ask the court to sentence him to.
What about the strangulation charge? Count 10.
He pled to it. I would ask you to run that concurrent because I think the strangulation kind of is part of the felonious assault. I mean, or that would be the one separate thing. It would be a different animus for the strangulation than it would be for the serious physical harm on the felonious assault. So frankly, if the court chose to run that consecutive, I think legally you'd be okay to do that. But I would ask you to fashion a sentence of whatever you see fit for 18 to 23 and a half. Thank you.
Thank you. Did your client wish to say anything? All right, let's make sure the mic is to it and. Go ahead.
Yes, ma'am. First, I would just like to apologize to the court for taking up everybody's time and resources for the situation I placed myself in and this court. Second, I would just like to say that this incident stems whenever we was both fueled up on methamphetamine, and I was already placed myself in a very bad situation. As they said, I was already on the run for an escape, and so I've had a lot of time to think about it and reflect. And just at this time, I'd just like to apologize to the victim and their family.
All right, thank you. Did the state want to respond to defense arguments that the felonious assault should merge for sentencing?
Thank you, Your Honor.
Concurrent, I guess, is.
Yes, if I could. Your Honor, I think we've already stated all the reasons why the court can find that the felonious assaults do not merge. I think counsel talked about our burden, but ultimately it's up to the court based on everything you've heard at sentencing, as the defendant has already entered a plea of guilty to each one of those felonious assaults. So, Your Honor, if you find that the state has convinced you that these beatings resulted in different injuries that were serious over the course of those 4 days, then that is the separate animus needed. And I believe that finding will stand up on appeal. Your Honor, the state also forgot to ask for the violent offender registry based on a conviction for the kidnapping, and also asked that the escape run consecutive as by law.
Thank you. Attorney Grevin, anything further?
No, like I said, I don't think they can point to what caused what, and because of that, I think serious physical harm is serious physical harm. I mean, Judge, if I shoot somebody 3 times, that is 3 times can be 3. I guess technically 3 times felonious assault, but it's 1 act. They would have to merge. They would have to be concurrent. If you do it on 3 separate days and run those consecutive, but I don't think that they've shown, and it's their burden, that whatever caused these serious physical harm, that 1 happened on a Tuesday and 1 happened on a Wednesday and 1 happened on a Thursday, they are not able to do that. So if they can't do that, I think that these necessarily need to be concurrent. And that's all, although I would ask the court, can you just come up, side row real fast?
Yeah, over here.
Yeah, please, do it in the court reporter.